A very good evening to everyone present here. I am Retd, Head Coordinator at LawInternships and the moderator for today's interactive session. We have amongst us Professor M.V. George, sir. Sir is an advocate selected to the Kerala judiciary. Sir has functioned as the first-class magistrate, Munsib, Sub-Judge, CGM District and Sessions Judge. After retirement, Sir is engaged as a legal consultant and a professor in Gregorios College of Law and a panel arbitrator of the High Court of Kerala. We welcome you, sir. Today, sir will be enlightening us on the topic how to draft a legal notice. So if any one of you has any questions or queries regarding that, feel free to ask us. Either you can unmute yourself after taking permission, or you can type your questions in the chat box. Thank you. Before delaying any further, let's begin the session for today. Over to you, sir.
Okay. Thank you for giving me an opportunity to interact with you for some time. And so, as law students, the drafting of notice is very important and part of your syllabus also. As part of your drafting and pleading, you have to undergo exercise in drafting and pleading, and in that notice is also required to be drafted by you as part of your syllabus. Okay, so well, when we speak of notice, you must understand what is notice. And in common parlance, we may say that it is giving an information or intimation or giving knowledge to the other party. We come across several notices. Even in your college, you may find there is a notice board displaying information to the students. Okay, and likewise, many of the government offices you will find notice board displayed for giving information to the public. Likewise, an individual, there will be several situations where you are required to intimate the other party by communication. So this is once, and as a lawyer, as student of law, you are required to know what are the steps that are to be followed while drafting a notice. Okay. Now, in the legal sense, we may say that it is a formal written communication to the opposite party informing your intention to initiate a legal proceedings. Rather, it makes the other party to know your grievances. So I'll repeat once more. What is notice in legal sense? It means it is a formal written communication to the opposite party informing your intention to initiate a legal proceedings. Rather, it makes the other party to know your grievances. So this is what is contemplated in, when we say a notice in the legal sense. Okay, now understand, sending a notice is the starting point of a litigation. So it is very important. Suppose you commit mistakes in sending notice, or you commit, say, a mistake of facts or law or whatever, then definitely it is going to affect the case also. Why? Because suppose you say something in the notice, some facts you have stated, and you cannot deviate from that facts, and you will have to stick on those facts what you have stated at the first instance. So this is very important while drafting a notice. So I have already said that it is a starting point of a litigation. So it is a part of, it becomes a part of evidence. Suppose you start a litigation, you may have to produce it as an exhibit, as an evidence, and that will be read in the disposal of the case as an evidence, and that will reach, suppose the litigation goes on, it goes up to Supreme Court, and it goes different stages of scrutiny. So the drafting of a notice is very, very important as far as a lawyer is concerned. Okay, then in another sense, we may say that what is a notice? It is warning of a legal action. We may, in a nutshell, we may say it is a warning given to the opposite party that you are going to proceed with a legal action. And secondly, you are giving an opportunity to the opposite party to resolve the dispute instead of a litigation. So you are giving an opportunity to the opposite party to resolve the dispute without going for a legal proceedings. So these are some of these elements that you will have to understand when we speak of a notice. Okay. Now you may ask, is it mandatory to send a notice in all cases of litigation? No, it is not mandatory. Only in certain cases it is made mandatory, not otherwise. Not otherwise. Okay. That we will, what are the types of cases where it is made mandatory? But mostly, you find that in most of the cases, it starts with a notice. So first of all, you understand that it is not mandatory to send a notice. And even without a notice, you can file a suit before a court. Okay. And in criminal cases also, in some of the cases, we will enumerate what are those. In some of the cases, it is required to send a notice to the opposite party, giving a warning that you are going to proceed and resolve the dispute. Okay. Now, let us come to the different stages of sending a notice, different stages of notice. First of all, it is, you will have to understand that there are some procedural requirements, or rather some formalities to be followed in drafting a notice. And it can be, it is not mandatory that it is to be sent to a lawyer. The party himself can send a notice directly to the opposite party. And it can be a personal notice as well. And when it comes through an advocate, certain formalities, that legal skill has to be reflected in the notice. So it is a formal expression of that has to find a place in drafting a notice. Certain formalities are to be kept in mind while drafting a notice. Okay, now what are the objectives? What is the purpose of sending a notice? That also you'll have to understand. What is the objects behind sending a notice? First of all, the objects behind is that I already said that it is a starting point of litigation. Then secondly, it reveals your intention that you are going to prosecute a matter. Then thirdly, you are giving an opportunity to resolve a dispute. Can you give me 1 minute? Just a minute. Okay. So it is a starting point of litigation. Then it reveals the intention of the party sending the notice. Then it is giving an opportunity to the opposite party to settle the matter. And next is you are giving an opportunity to know what are your grievances. This is another purpose in sending notice. And fourthly, it is you are giving a warning, a final warning to the party that you are going to proceed with a case. And next purpose is to avoid a litigation and to come to have maintain a cordial relation between the parties. That is also one of the purpose in sending notice. Okay. And next is before sending a notice, of course, there will be situations where the parties may have dialogue each other for resolving the dispute. It is only at the last stage that he goes for a litigation. So, and before, and it is a last warning to the party that you are going for it. So it can be said as a reminder to the opposite party to solve the issue. And next, the advantage of purpose in sending notice is to create it as an evidence of demand. That is very important. It creates an evidence. You are bringing, rather setting forth an evidence that you made a demand. Because there are certain cases where you have to make a demand. For example, the simple example I may say that demand promissory note. You have to make a demand. Demand promissory note, you have to make a demand of repayment of the money, and then only he is obliged to pay. So you can say that it is that you have made a demand to the party, in spite of the demand, he did not pay. Okay, so this is, then it will establish the credibility of the case. When it goes to the court, the matter goes to the court. and the court will view it in your favor in the center of the notice that, of course, to avoid a litigation, he had sent a notice. And in spite of the notice, he did not respond and he did not carry out the, rather, remedy the grievances of the sender. So it brings in credibility of your story. So these are some of the objectives and advantages of sending a notice. Okay. Now let us understand what are the types of cases where you are required to send notice. It can be sent in almost in all civil cases. You can send notice to avoid these litigations. Or that is, it can be a mortgage suit where you have mortgaged the property for security of money. Then it may be you want to evict a tenant, you can send an eviction notice. Then suppose you want to repossess a property, you can send a notice. Then suppose you want to have partition of your property, the other parties are not cooperating, well, you may send a notice. These are some of the pure civil matters where you may send notice so as to avoid litigations. Okay, then there are some certain rights which you are entitled, where also you may send notice to avoid a litigation, so that your purpose is to avoid a litigation and get your problem solved. So it may be solved by sending a notice. So it may be you are an employee and you are wrongfully terminated. So well, you can send a notice warning that you go for a litigation, otherwise pay compensation or reinstate. Okay, suppose you are not paid your salary, well, you can send a notice that you pay the salary. Failing, I will proceed with the suit. Okay. Then there are, suppose, of course, it is made mandatory in strike matters. The employees, before going for a strike, it is required that you give a strike notice. Okay. Then there will be other situations. Suppose money is to be paid back, and also you can make a demand of getting the money you. So these are some of the suits or litigations where, okay, and the in-person litigation, those are maybe in a matrimonial case, in a divorce matter, the wife or the husband has withdrawn from the conjugal relation, and well, before going with the petition to the court, well, you may send a notice to the spouse, okay, rejoin, otherwise I have no other go than to approach the court of law to get my grievances redressed. So well, in divorce case also, or to avoid a lengthy litigation between the spouses, well, you may want to go for a mutual consent divorce. Well, you can send a notice to the opposite party. Well, come forward. We will have an amicable resolution of our issues, and we will separate. So such a notice can be given. And in maintenance cases also, well, you can demand the husband, okay, maintenance of the rate so much. Otherwise, I will approach the court of law. Then custody of the children is also, you can make a demand to the opposite party, produce a child or allow me to have visitation, etc., etc. So these are some of the personal matters also where you can send legal notice. Okay. Now I said that in criminal case also, certain cases are there where you are required to send a notice. That one such case is Negotiable Instrument Act, is Section 138 of the Negotiable Instrument Act. Check bouncing cases. You are aware of the check bouncing cases. And in those cases, it is made mandatory. The punishment is 2 years imprisonment. It is a criminal offense. So it is made mandatory that before you initiate a prosecution, you are required to give a notice to the opposite party within 30 days of the dishonor of the check, demanding the payment. And you will have to wait for another 15 days. And he should be given 15 days of time to meet your demand. And if he fails to pay within 15 days, then, well, cause of action arises. You can approach the court of law and file a criminal case. So that is one case where in a criminal case also, you are required to send a notice. Okay. Now, then another important thing you have to remember is suits against government or its officials. If you want to initiate a suit against government or its officials, it is mandatory that you shall issue a notice under section 80 CPC, Civil Procedure Code. Under section 80, it is mandatory that you should send a notice to the government or its officials, even if it is against the government or any of its officers in their official capacity, not personal. Don't be confused. Only officials in their personal capacity, sorry, in their official capacity, if some wrong is done, and to rectify those things, well, you are required to send a notice mandatorily. And 60 days time has to be given. The time limit is also given. 60 days time has to be given for the opposite party, rather the government or its officials, to remedy the grievances. And then only you can file cause of action. Cause of action has already arisen, but you can file the suit only after waiting for 60 days. Then only you can approach court. Of course, in exceptional situations, maybe emergent matters, well, there is a power given to the court to waive this mandatory requirement of sending notice under section 80 CPC. Of course, we don't have time to discuss elaborately on those aspects. I think you have already studied in your CPC. Okay, these are some of the various types of suits, litigations where you are required to send notices. Okay, now coming to the major aspects of a notice, what are the things you have to remember in drafting a notice? First of all, please remember, normally it is sent by a lawyer on behalf of his client. And it is always advisable for a litigant to approach a lawyer because he is an expert in legal matters. So it is always advisable, better to approach a lawyer for sending a notice before the litigation. So the name and full particulars of the sender has to be mentioned at the top. If it is sent by an advocate, it shall be in his letterhead, where all his particulars are to be mentioned. And next, if it is sent by the advocate, the name and address of the person who is under whose instruction the advocate is sending the notice, rather the person who is going to prosecute the matter has to be clearly mentioned to make the other party know who is the sender of this notice, who is the originator of this notice. So name and address of the name and address of the sender of the notice has to be compulsorily mentioned, and also the person for whom you are sending the notice has also to be detailed if it is sent by an advocate. Then the next is name and address of the recipient, the opposite party, has also to be clearly mentioned. The identity, it should not be, there are some instances where in my practical experience I have seen, because of the deficit address, because of defective address, the notice may return. So again, it causes delay. So you should ensure that proper address is mentioned, postal address is correctly mentioned. All before sending a notice, all particulars warranting to reach this notice by the recipient has to be collected by the advocate, and then only he should send a notice. So the name and address of the recipient, next step. The next is starts with a salutation. You have to address the recipient as sir or madam. Whoever is the recipient, accordingly, you have to address salutation. Then you can give the subject, notice you can mention. Then the body, then is the body of the notice. That is the facts in brief. You need not to mention each and every details or particulars that are required to be furnished while drafting a plaint. When you go with a suit in a court of law, you are required to draft a plaint in accordance with Order 7, and the plain particulars are to be there. Whereas in the notice, You are not required to state everything, but it should contain matters which the other party has to know, or revealing your grievances. What are the facts, or what is the circumstance under which the notice is issued? All this has to be stated in brief. Okay. And next is you have to mention cause of action, or what grievances you have and when it has arisen. And then next important is relief. The matters which has to be remedied by the opposite party has to be mentioned towards the last of the notice. Then don't forget to sign. The sender has to sign. If it is sent by the party himself, he shall not forget to sign the notice, and advocate shall ensure that this matter is signed, because there are instances which comes because of carelessness. I have seen certain litigations where notice is sent, but it is unsigned. It has no validity. It will not be accepted as evidence because there is no author. There is no person who has authorized for the sending of the notice. So it becomes invalid. So ensure that the signature is contained. Then next is the place and date where from these or letter is sent, the notice is sent. So what are the particulars you are required to ensure that are contained in a notice? First of all, name and particulars of both parties, then the salutation, then the subject, then the facts in brief, then the cause of action, then the relief, then signature, date and time, date and place. So these are some of the basic requirements that should find a place in the notice. Okay. Now, how to send a notice? Is it enough that you can personally hand over a notice to the opposite party? Well, there is no legal impediment. You can hand over a notice to the opposite party. But what will happen? Of course, you may say that you have personally approached him and handed over the notice. Well, this can be denied by the opposite party. I never received it. So what is the matter you have to ensure in such a dealing? You have to ensure that it is acknowledged by the party. You hand over a notice and get it acknowledged by the opposite party. It is not required that you should send it by registered post. Personally, you can hand over, but get an acknowledgement of receiving the notice. Then only it becomes enforceable, rather valid. Okay. Then, as far as sending by post, you please ensure that it is sent by registered post with acknowledgement due. This is very important. Why? Because in litigations, we can find two enemies fighting in a court of law. So they will take all kinds of defense to escape from the litigations. So they will, if the notice is sent unregistered in ordinary post, he will take a plea that I never received it. And what is the evidence for you to show that it is received by him? So in order to ensure that the opposite party has received the notice, please ensure that it is sent by registered post with acknowledgement due, so that you will sign the acknowledgement and you will get back the AD card, and that will be an evidence of service of notice by the opposite party. And well, ensure that the postal receipt you receive from the post office also is kept safe, so that even if the AD, the acknowledgement card has not returned or it is missing due to some reason, well, you may produce the postal receipt so that you can prove that you dispatched a registered notice, because it has got a legal presumption. Once Section 27 of the General Laws Act says that if you post a letter or a matter by registered post in the correct address, duly stamped, it is presumed that it is delivered to the addressee unless it is returned. So there is a presumption. Even if the AD card is not returned or it is missed during the course of transaction, then you can produce the postal receipt before the court and request the court to draw the presumption against the opposite party to prove that you send the notice, because there is a presumption is that once it is dispatched by registered post in the correct address, duly stamped, it is presumed that a registered article is delivered to the addressee unless it is returned. So this is a legal presumption. Okay. Then another important thing when you have to remember is when you draft a notice, please, as a lawyer, when you draft a notice, please mention that you are issuing the notice under instruction of your client, under instruction of your client, Mr. So and so. That should be clearly mentioned in your notice. Because I know a case where a defamation case in which advocate has sent a lawyer's notice to the opposite party, making some accusation, touching his personal character in the notice. Then there was a defamation case against, not only against the party, but also against the advocate, because it is sent by an advocate. Then the question arose whether the advocate is liable for defamation. So that is why I said you have to clearly mention that you are sending this notice under due instruction from your client, not on your own. So that responsibility has to be shifted to your client. You are acting under the instruction of your client in sending this notice. So whatever contents stated by the advocate in the notice, the responsibility will go to the client. So that is the importance of sending a notice under the instruction of a client. And next is give a time limit. I said it is a starting point of litigation. Give a time limit. Maybe 15 days or 30 days. Within 15 days or 30 days, a reasonable time shall be given to remedy the situations or to redress the grievances. A time limit shall be stipulated so that the opposite party will get an opportunity to redress the grievances. So giving a time limit in the notice is also an important step you will have to remember. Then next matter you will have to remember is what will be the consequence of failure to comply with the requirement of the notice. Suppose the opposite party does not comply with your requirement. What is consequences? Towards the end of the notice, you have to say if you are directed to, suppose it is a money matter, you have to make a demand, saying that you are directed to return the money or pay back the money within 30 days of this notice, and failing which you shall be proceeded in accordance with law. So the consequences of compliance shall also be stated in a notice. Then you can also mention that instead of a litigation, let us go for a settlement. You please come forward with a settlement so that we will avoid a litigation. So these are some of the important steps you have to remember when a notice is sent. Okay. Now, and there are some more matters you'll have to remember while drafting a notice. One is I already said that a party can draft the party can send the notice by himself, and and also through lawyer. And it is always advisable that you print the matter, you get it typed, print the matter, and send it. Otherwise, there will be difficulties in suppose the handwriting is not legible, and there will be a lot of complaints, and it is not appealing. So it is always proper and better that you print the notice and send. And then always remember, very important, always remember, you always keep a copy of the notice you have sent. The original shall be dispatched to the opposite party, and the copy shall be retained by the party till the end of the litigation. And with the start of the litigation, you may require it to be produced before the court of law as an exhibit, as part of evidence. So always keep a copy of the notice that you sent. Okay. Then next, you may have doubt whether it is mandatory that it should be sent only through post. It's not mandatory. It should be sent only through post. Recently, because of the advancement of modern technology, there are other means of communication, email, WhatsApp, then etc. are also permitted. And recently there was a Supreme Court decision that even sending a notice by WhatsApp message it will amount to sending notice, because there is acknowledgement. You can have it from the WhatsApp messages. Then it can be sent through courier services also. Courier services can be availed. So these are some of the mode of sending notices. Okay. Then some other matters which you have to remember is so these are some of the very important steps that you have to remember in sending a notice. And I also said that what are the situations where you are required to send notices. And in some cases it is mandatory, and always ensure that proper particulars are contained in the notice. These are some of the matters you will have to remember as a law student and as a lawyer in future before sending a notice. Okay, now to conclude, I may say that what are the things that I have discussed now? It is a formal legal, it can be said that it is a formal document, and normally it is prepared by an advocate for his client. So it is a formal legal document prepared by an advocate for and on behalf of his client before the commencement of the litigation. And next, it is not mandatory in all suits. Then the next thing is that it is an important document in a legal proceedings. Sometimes it becomes a vital evidence in a court. Okay. Then you are giving an opportunity to the opposite party to have an amicable settlement. Then it should be in a presentable manner. Please ensure that you use proper language. Unparliamentary words should be avoided. So make it presentable, understandable to the opposite party, and it should be very legible, clear to the opposite party. All the matters shall be, all details should be represented in the notice that you send. So it should be in a presentable manner, in a proper language. No improper words shall be used in sending notice. Okay. Then these are the matters which the requirements of sending notice, the contents of notice, etc. I have stated now. So, and one more thing is, in certain cases, you may have to send a reply also. So such notices, suppose you receive a notice from through a lawyer. Well, the party may not know the legal intricacies, so he may take it to another lawyer, and that lawyer may send a reply. So it is called a reply notice, maybe denying the claims, or it can be giving an explanation as to the matters. So such kind of reply can also be given, but it is not necessary, it is not mandatory that reply is given. But there are situations, there are circumstances where if you do not send a reply, an adverse inference shall be drawn against the party who received it, that he is admitting it. Of course, it is not always so. Court goes by evidence. But of course, there is an adverse inference. Sometimes an adverse inference can be drawn against the recipient if he is not sending a reply. So these are some of the matters that you will have to remember as far as a notice is concerned. So I have given you an outline as to what is notice and the requirements of notice, the purpose behind sending notice, and what are the steps that you have to follow in sending notice, etc. So let us have a dialogue, let us have a discussion, and you can ask your doubt.
Sir, shall I share my screen for the draft which was shared by you regarding the legal notice?
Okay.
So if you could just go over that legal notice so that the students can have a look at it and understand what you have just explained now. So.
Is my screen visible?
Not me.
No, Riddhi. Can't see.
There's some error coming actually while sharing the screen. Just give me a second.
Sure.
Now is it visible?
Yes, it is not.
Not yet.
Not visible in my screen.
Actually, there's some technical glitch coming from my end.
Am I enabled to share? I don't think so because post disabled participant screen sharing.
Ma'am, I'll enable your screen sharing if you can please do it, because
Please.
from my
Yeah.
side it is not being given. Just hold on. Can you share the screen now, ma'am?
Yeah, hold on. I'll try.
Yes, ma'am. In the meanwhile, can we take some questions, sir? Students have
Yes,
asked.
please. Yes.
There's a question from Isha Gupta. She's asking how party will get to know that case has been filed against if no notice sent to him.
Okay, well, when after instituting a suit, it is duty bound to the court to send a summons. It is called sending a summons. So summons has to be sent to the opposite party, and he will get to know, he will come to know that a suit has been instituted. Even without a notice, a summons has to go. Notice, don't be confused with the notice sent by the court and the party. The notice by the party is before the litigation, before going to the court. Okay, I already said that it is a warning to the opposite party that I am going to court. So it is notice, what we discuss now is notice sent by the party to the litigant, but party to the opposite party. Whereas instead of summons, there are instances where notice is sent by the court, because in petition matters normally notice is sent. Okay, and notice is sent by the court. So notice sent by the court is different than the notice sent by the party. So party will definitely know that a suit is instituted or a petition matter is filed.
Thank you, sir.
Without which it cannot be proceeded. See, serving notice by the court is compulsory, mandatory. Otherwise, it is defective. The proceedings, the entire proceedings will be vitiated. Okay.
Yes, sir. And the next question we have, does the legal drafting also done in corporate fields?
Say again, repeat.
Does the legal drafting also done in corporate fields?
Yes, definitely. To avoid a litigation, the purpose of sending notice is to avoid litigations. Well, notice can be sent, no doubt.
Okay, sir. And the second question as well from Sahil. He's asking, legal drafting is same for every field or any change in every field?
It is more or less same. There is no change. The only thing, it depends upon the nature of the litigations. That is why, that is what I said, you are stating the facts. But the basic requirements are what I have stated earlier. The particulars, the facts of the case, the cause of action, the relief claim, all these are almost same. Only thing, the nature of litigation will be different. So the nature of drafting of the notice will also be different. Otherwise, basically, the fundamentals are same.
Okay, sir. And the next question is from Jaymeet. He's asking, can a legal notice be handwritten?
No harm, no harm. But it is always advisable to print it and send it. It can be written in handwriting, can also be, but it should be legible. It should be legible and readable. Otherwise, there will be room for complaints, grievances. Okay. There is no legal prohibition in sending a handwritten notice.
Okay, sir. And the next question from is it mandatory that a legal notice must be in English language only?
No, it is not mandatory. It is not. It is not mandatory that legal notice shall be in English. It can be sent in local language also. But in most of the courts, the language in most of the states, the language used is English. It's only very few states that they have changed over the medium to the local language. So it can be sent either in English or in the local language. Okay.
Sir, I have just opened one of the draft notice that you had sent me, and this, yes, was regarding some payment for some apartment that was to be bought.
This is okay. This is one. See, I have said that you look at the particulars. At the top, you will find the name of the advocate. Then the particulars, the full address has to be stated there. Then it is addressed to whom. The full particulars has to be stated there. And if there are more than one party, 1 by 2 serially, you can number them. Then the salutation. Then look at the next para. Under instruction from my client, so and so. So that is very important. When an advocate sends a notice, always write you are acting under the instruction of your client and sending a notice. What is a subject? That it is a notice. And this is a case where a company, a construction company, has defrauded the customers and took off their money, and the parties have booked for apartments and received money, but he committed breach. The company has committed breach that failed to construct the building complex. So there was a breach of contract. Then the client has demanded to return the money, rather withdraw from the contract. Then finally, there was a terms of understanding permitting the party to withdraw from the contract. Then accordingly, for the money due to the party who has booked the flat, was issued with checks. And that check, when presented, returned dishonored. Checks were bounced from the bank. So notice was sent to the party and before initiating a prosecution. This is a case for filing NA Act case, section 138 NA Act. If you look at the bottom, you can find section 138 NA Act. So it is a warning. At the end of the paragraph, you can read, I hereby intimate you the dishonor of check number so and so, and demand you to pay the amount within 15 days of the receipt of this notice. You are hereby informed that on your failure to pay the amount by my client within so many within the stipulated period, you shall be prosecuted in a court of law for offence under section 138 of the NA Act. And in that event, you have to face the consequence. So this is the final conclusion of a notice. And the signature, the name of the advocate, then the signature, the date, etc. So this is a typical model notice. Okay. It is a mandatory notice which is required to be sent before instituting a case for check bouncing cases. I think you can look at it contains all the particulars. See, one more thing: when you send a notice, you need not to the words about when you send a personal letter, an informal letter, you will normally conclude by yours faithfully or yours sincerely. No such requirement is there in a legal notice because it is a demand. It is a legal step. See, you look at the bottom, the date, then straight away the advocate can sign it because it is a legal notice. There is no question of mentioning faithfully or sincerely, because it is not personal, it is official, because legal notice is an official document. So that is why our requirement of stating yours faithfully or yours sincerely. Okay. Yes. Yes. Any other?
Yes, sir. We have two more questions as well. Um, can someone go for legal proceedings without giving legal notice to other party? Will he be questioned by the judge?
No, no, not at all. Not at all. But if in section 138 cases, in section 138 NA Act cases, if you don't send a notice and go for a suit or go for a criminal case, well, that is a defect. That is a defect at the very beginning. But it is a defect ab initio. So what will be the consequences? Your petition will be dismissed ab initio, because it is not maintainable. Your petition, your criminal case itself is not maintainable for want of notice. So judge will not ask, but only thing, it is a legal requirement. The judge is a neutral person. He is an impartial person who is to render justice to both parties. So he will not find fault with the opposite party for not sending a notice, or judge will not ask. It is only thing you will have to answer to the questions put by the opposite advocate. Cross-examination you will have to face. So that will be your responsibility, and the court will only decide as to the legality, as to the merit of the case. Judge will not ask such questions. Okay.
Okay, so thank you. Next question is, in what criminal cases a legal notice is mandatory?
It is mandatory only in 138 NA Act cases. And of course, against local bodies, Panchayat in Kerala, there is a Panchayat Raj Act where you have to send notice before initiating a prosecution, labor matters, etc., labor dues, etc. Notice is prepared before initiating prosecution. Otherwise, in criminal cases, it is not required. Criminal cases are mostly crime against society at large, crime against the causing bodily injury to a person, etc., etc. Or so such matters, no need of setting a notice, because the guilty has to be punished. So it is the duty of the society. So and moreover, in a criminal case, the complainant is a state, and the aggrieved person is only a de facto complainant. He will appear as only witness, and it is a duty of the state to prosecute. So there is no need of notice in criminal case, except because as far as this 138 NA Act case is concerned, police has no jurisdiction to file a case. Police has no jurisdiction to file a charge sheet. It is only party in person has to approach to the magistrate and file a case. So it is a private complaint. So only in such cases you are required to send notice. Okay.
Sir, is there any limit in the number of pages in drafting a notice?
Say again, is there any limit?
In number of pages while drafting a notice?
See, it should be as far as possible very brief. You only state the facts. I have said that when you file a suit in a court of law, all the particulars that are required to be mentioned as per the CPC has to be stated. Otherwise, it is defective in pleadings. Whereas in sending notice, all those details need not be mentioned. You only state, focus on the fact. Only give a mention, not the entire facts. Focus on what happened. Then how the cause of action has arisen. And then what is your grievances and how it is to be remedied. Only this much, nothing more. So it is always advisable. It should be made as brief as possible, preferably in one page. Preferably in one page, because a lengthy notice will be more cumbersome. It will be more complicated.
Right, sir. And so the next question is there any rule or law regarding the word limit of legal notice?
Rule of law regarding?
Word limit of legal notice.
There is no such rule. there is no such rule in word limit. No such rule is there. But it is always, after all, it is a principle of pleading that it should be brief to the point. It should be brief to the point, making out all facts and legal aspects contained in a litigation. So there is no such rule. It is only stated brief. As far as possible, state facts in brief, nothing more.
Okay, sir. And the next question is, to whom, where we have to send the legal notice if the case is against the state?
It is against, see, after all, the responsibility, the state is represented by the Chief Secretary of the state. Chief Secretary of the state. If it is union government, so shall we wind up?
Sorry, sir. Actually, I had some technical glitch from my end. Yes, sir. We are done with the questions. Any more questions? If anyone has any queries or doubts regarding legal notice, you may ask your questions to sir. Any one of you?
If there is no question, we will wind up. Okay.
Yes, sir. There's one question. Is it necessary that a notice must be written by a lawyer?
No, it is not necessary that a lawyer, only a lawyer can send a notice. But why a litigant need to approach a lawyer? Because lawyer is an expert. You are availing the service of an expert, legal expert. So that is why we always prefer to go to a lawyer and send notice. Otherwise, the party himself can send notice directly. Only thing, the danger is that the party will not know. Party doesn't know the legal procedure. And there are some matters, as far as the litigation is concerned, there are some matters where you have to, some facts may have to be hidden. Some facts may not be stated. And suppose you state those facts, sometimes it may go adverse to you. So such things only an expert can scrutinize and decide as to the contents of notice. If the party send, he will only state his grievances. He will only state his crime, nothing more. He only knows to tell his story. So sometimes it may go damaging the end of the litigation. The result of the litigation may be affected if parties send notice directly. Otherwise, there is no bar if parties send the notice directly. Even cases, it's not required that a lawyer has to be engaged in conducting a case. The party himself can conduct this in person. That is called case conducted in person. Party can tell all details, but the only thing it should be as per the legal procedure. Nothing more. Okay. So,
yes, so we are done with the questions. So for that, I would like to move with the vote of thanks. I, Riddhi Jindal, on behalf of Team Law Internships, extend my heartfelt gratitude to Professor M.V. George, sir, for taking out time from his busy schedule and interacting with the young minds. It was truly an enriching session, sir. I am really sure that the students must have taken out few insights from your session on how to draft legal notice. Thank you so much.
okay, thank you very much for giving me this opportunity, because
Pleasure,
I love
sir,
students.
pleasure.
That is why even after my retirement, I love teaching also. So that's why I started teaching in law college. So it is a very good opportunity given to me. And thank you very much. Wish you all the best in future.
Thank
And
you
hope
so
you
much, sir.
be future lawyers and judges. Thank you very
Thank
much.
you so much, sir.
Thank you, sir, for
Thank you, sir.
inviting.
Thank you, sir.
Thank you, sir, for accepting our invite. Thank you.
Bye. Shall I leave?
Thank you, sir. Thank you.
Yes, sir.